Two teenagers. Same crime. Same night. One gets 7 years. The other gets life. The only difference? A single birthday. And what decides which children face adult prison will shock you. In 2019, Marcus Johnson and Devin Williams broke into a home in Georgia. The homeowner confronted them. A struggle ensued. The man died from injuries sustained during the altercation. Both teenagers fled together. Both were arrested the same night. But here is where their stories diverge in a way that defies logic. Marcus had turned 17 exactly 8 hours before the crime. Devin was still 16. Georgia law automatically transfers 17-year-olds to adult court for certain felonies. Marcus faced life without parole. Devin entered the juvenile system with a maximum sentence of 7 years. Same crime. Same victim. Same night. One birthday apart. And this happens across America every single day. But the question nobody asks is this: who actually decides which children face adult consequences? The juvenile waiver system was never designed to be fair. It was designed to be flexible. And that flexibility has created a patchwork of laws so inconsistent that your fate depends entirely on geography. In Texas, children as young as 14 can be tried as adults for capital felonies. In Vermont, the juvenile court has jurisdiction until age 22. Cross a state line, and the same 15-year-old facing the same charge could receive rehabilitation in one state and life imprisonment in another. But here is what most people do not realize. There are 3 different ways a child can end up in adult court. Judicial waiver, where a judge decides. Prosecutorial discretion, where the district attorney decides. And statutory exclusion, where the law decides automatically with no human judgment at all. If this sounds like a lottery system with children's lives as the stakes, that is because it is. Now let me tell you about Nathaniel Abraham. In 1997, he was 11 years old when he shot and killed a man in Michigan. 11. He could not legally drive. He could not vote. He could not buy cigarettes. But prosecutors decided he could face murder charges as an adult. Think about that for a moment. The state argued that this 6th grader possessed the same criminal intent as a grown man. The same understanding of consequences. The same moral culpability. Nathaniel's defense team presented evidence that he had the mental capacity of a 6-year-old. It did not matter. The judge allowed the adult prosecution to proceed. After 3 years of legal battles, Nathaniel was ultimately sentenced under juvenile guidelines and released at 21. But here is the disturbing truth. If that same case had happened in another state, or just a few years later, Nathaniel Abraham could have spent his entire life in prison. The prosecutors who push for adult charges will tell you it is about public safety. They will cite heinous crimes and demand accountability. But the data tells a completely different story. A comprehensive study by the Centers for Disease Control found that juveniles transferred to adult court are actually 34% more likely to reoffend than those kept in the juvenile system. Read that again. Adult prosecution does not reduce crime. It increases it. The juvenile system, despite all its flaws, focuses on rehabilitation. Education. Therapy. Reintegration. The adult system. It is punishment and containment. When you take a 15-year-old and place them in an adult prison, you are not creating a reformed citizen. You are creating a hardened criminal. You are exposing them to violence, exploitation, and survival tactics that will define their psychology for life. And then we act surprised when they reoffend. But here is what the legal system refused to acknowledge for decades. And this changes everything. Teenagers are not small adults. Their brains are fundamentally different. The prefrontal cortex, the part responsible for impulse control, risk assessment, and understanding long-term consequences, does not fully develop until age 25. 25. That is not opinion. That is neuroscience. When a 17-year-old commits a violent crime, they are operating with incomplete hardware. They literally cannot process decisions the same way adults do. In 2005, the Supreme Court finally acknowledged this in Roper v. Simmons, banning the death penalty for juveniles. In 2012, Miller v. Alabama banned mandatory life without parole for children. But here is the catch that most people miss. These rulings did not eliminate life sentences for juveniles. They simply require judges to consider youth as a mitigating factor. Children are still serving life sentences in American prisons right now. Let me tell you about the case that haunts every juvenile justice advocate. In 2003, 2 boys in Florida were involved in a robbery where a woman was killed. One boy was 15. He received life without parole. The other was 14. He received 30 years. Same crime. Same circumstances. 1 year of age difference resulted in decades of additional punishment. The 15-year-old, Joe Sullivan, was convicted partly on testimony that was later recanted. Evidence suggested he may not have been the actual perpetrator. But Florida's direct file law had placed him in adult court automatically. No hearing. No evaluation. No consideration of his circumstances or mental state. Just a birth date on a document that sealed his fate. And here is the question that should keep every American awake at night. We do not trust 17-year-olds to vote or buy alcohol, but we trust them enough to hold them to adult criminal standards. So who actually benefits from this system? Follow the money. Private prison corporations receive more funding for adult inmates than juvenile detainees. Prosecutors build careers on tough on-crime convictions. Politicians